thing. You should read the Declaration of Independence. You should read this right here. This is an affidavit of denial of corporate existence. And you should read one more thing. This right here is a notice to the judge. This is a notice to the judge. This right here is let the judge know we have a memorandum of law also on the right to travel. So this is right here to the judge. So the judge won't be confused about your status before the court. This is one of the best letters I've ever seen written. Sit back and listen to this. All right, so let's look at it. This is a letter to the judge, and it goes, "The Honorable Judge so-and-so, when I specially visit your court on a forced response on such and such date to a bill of pains and penalties." A bill of pains and penalties is when they're taking you through a process without subjecting you to judicial process. This is why it's important for you to know the difference between an administrative court and a judicial court. As real living souls, as the people of the republic, as private citizens, we are only supposed to be subject to true judicial process before a true Article III judge of the judiciary or whatever branch of government you have in your state legislature, however that delegation of powers is stylized in your Constitution, okay? That is what that is talking about when you say a bill of pains and penalties. They're taking you through some sort of process and having a presumption that you're some sort of artificial entity and ignoring the fact that that's what a legal fiction is. A legal fiction is an assumption that something is true, even though it may be untrue, but especially in judicial reasoning to alter how legal rule operates. So we operate in the land of fictions and frauds and legal fictions, and y'all out there attorneys are trying to act like we're not, which is just an insult to anybody's intelligence if they've done a cursory investigation into any of this information. So right here, this is what bills of pains and penalties is talking about. So we go on, it says, issued by the officer so-and-so, employed by the police agency, employed by the corporate state of Georgia. I move this court and you, George so-and-so, to take judicial notice that my special visitation was forced, that my visitation is special and not general, since this notice is my timely and specific objection to the presumptions upon which a false conclusion of law has been made administratively with regard to my status before this court. The plaintiff in this case is an administrative officer representing the corporate de facto state of Georgia, which has legislative power to compel performance upon the letter of its statutes upon all persons subject to its jurisdiction. You're going to listen to this administrator admit that she can't change the law. It was a $2,000 fine, and he has to do it because the legislature said so. That right there is a red flag. That lets you know that we're dealing with an administrator and not a true judicial officer. Because under separation of powers, each of the individual branches are warring with each other. So if it's a true judiciary, they don't have to follow what the fucking legislature says. That's why they strike down laws. They can say, hey, this is unconstitutional. But this judge is not doing it. She has a ministerial duty that she's doing. We need to look up the word ministerial duty. Ministerial duty. Write that word down because we're going to look at it later. All right, so the plaintiff in this case is an administrative officer representing the corporate and de facto state of Georgia, which has legislative power to compel performance upon the letter of its statutes upon all persons subject to its jurisdiction. The only due process that this legislative court recognizes is the right to be heard on the facts of the case. That's all. They do fact finding. The judge is a fact trier. The jury is a fact trier. If there's not an agreement of the facts, you're going to go to a jury trial. If there's a material issue of fact, if you're going to go to a jury trial. If there's an agreement on all the facts, there's no need to do that. And that's what we're looking for. We're looking for an agreement of the parties. We're looking for the spirit of Matthew 5:25, when it says, agree with your adversary before you go to court. Unless he hand you over to the judge hand you over to the bailiff, and you be cast into prison. I'll tell you, you will not come out until you pay the very last penny or farthing. Farthing means penny. Look it up, all you Christians, right now. Matthew 5:25. All right, so we go on. It says, the corporate plaintiff in this criminal action before this court has made an unproven conclusion of law that use of bail is among those persons who have lost or otherwise abandoned their status in the guaranteed Republican form of government and who must perform under legislative power upon the exact letter of every legislative statute with no due process of law protection other than that outlined in paragraph 2 of this letter. It is from this false conclusion of law that the administrative officer so-and-so, issued the contested bill of pains and penalties upon use of bail. The court must take judicial notice that use of bail is an unfranchised. Remember I said another name for a straw man is a franchise? Because that's coming out of Washington, D.C. Their jurisdiction is that 10 mile square. That's Article 1, Section 8, Clause 17 outlines the jurisdiction of the federal government. All right. So right there. All right. So for how did I've never been to Washington, D.C., so I'm a U.S. citizen. Well, it has to be some sort of corporate franchise. All right. So use of avail, an unenfranchised individual has made a contrary conclusion of law to that of plaintiff. Use of avail claims his guaranteed fundamental and unalienable rights stemming from both the national and state constitutions to full due process of law and all criminal actions against him means he is subject only to judicial power, not legislative power. Said judicial power, when exercised over him, requires a corpus delicti or a damaged party who has sworn out a verified complaint against him. This is what we're talking about, the state of Georgia versus my all caps name. And then they'll talk about to you like you're crazy for believing in a straw man, but state of Georgia can somehow prosecute me and in the Constitution have a protected right to face my accuser. And so when you say, and I say you have a claim against me and you say state of Georgia, and I call Georgia to the witness stand, I'm the one who's crazy? It says on the caption of the pleading, state of Georgia versus use of avail. So if I call the state of Georgia to the witness stand, Mr. Attorney, is somebody going to answer for that? Or are you just representing the state? I understand that. I'm intelligent enough to understand that. But how do we get to this thing that I have a right to face my accuser? Okay, and is it not true that there has to be some sort of injury? And with that injury, that to be a sworn out verified complaint, an affidavit from someone who's been injured. Because if I have not injured anyone or their property, who have I hurt?